All rise. Vive la paix. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Good morning. Would the court officer please call the case?
Good morning, Mr. President and Your Honors. Situation in the Islamic Republic of Afghanistan. Situation reference ICC 0217. And for the record, we are in open session.
Thank you very much. My name is Piotr Hofmański, and I am the presiding judge in the appeal of the prosecutor against the decision of the Pretrial Chamber 2 of 12 April 2019 on the authorization of an investigation into the situation in the Islamic Republic of Afghanistan. The other judges of the Appeals Chamber on this appeal are Judge Howard Morrison, Judge Luz del Carmen Ibanez Carranza, Judge Salami Balongi Bosa, and Judge Kimberly Prost. May I ask the parties and participants to please introduce themselves for the record, starting with the Office of the Prosecutor who appeals we are deciding today.
Good morning, Your Honors. My name is Fabrizio Guariglia. I'm Director of Prosecutions. Appearing with me today are Ms. Helen Brady, Senior Appeals Counsel, Mr. Matteo Costi, Appeals Counsel, Mr. Matt Cross, Appeals Counsel, and Mr. Manoj Sachdeva, Trial Lawyer.
Thank you very much, Mr. Yeah. And then I would ask a legal representative of the government of the Islamic Republic of Afghanistan.
Good morning, Mr. President, Your Honours. Rodney Dixon, counsel for the government of Afghanistan, instructed by and with His Excellency Mohammed Azizi, the ambassador for the government of Afghanistan in The Hague, and Sanya Siddiqui, and assisted by Aidan Ellis and Anne Connaught.
Thank you very much. And legal representatives for victims, we have the for 1 and 2 in the courtroom.
Good morning, Your Honors. My name is Nada Kiswanson van Hooydonk, and I represent 82 Afghan victims on behalf of LRV1.
Thank you.
Good morning, Your Honors. Catherine Gallagher from the Center for Constitutional Rights in New York, representing Sharkawi Al-Haj and Khalid Al-Duran, 2 victims who remain detained in Guantanamo without charge. And on behalf of the legal representatives for Mr. Al-Assad, Mr. Rabbani, Mr. El-Nashiri, and 2 others, I convey their regrets that they cannot be here in court today.
Thank you very much. I would like to ask the legal representative of victims OPCV, please.
Good morning, Mr. President, Your Honors. The office is appearing today representing the general interest of the victims in the situation. My name is Paulina Massidda, Principal Counsel. I'm accompanied today by Ms. Sara Pellet, Counsel, and Ms. Anna Bonini, Legal Officer.
Thank you very much. And last but not least, Amici Courier, OPCD.
Bonjour, Monsieur le Président, Excellences. Pour l'OPCD, je suis accompagné aujourd'hui par Madame Marie O'Leary, conseil, Monsieur Michael Hers, conseil adjoint, et je suis moi-même Xavier Jean Keita, conseil principal. Je vous remercie.
Merci, Mr. Keita. Thank you very much. I shall now summarize the Appeals Chamber's judgment on the prosecutor's appeal. This summary is not a part of a written judgment, which is the only authentic account of the Appeal Chamber's ruling and reasons. The written judgment will be made available at the conclusion of this hearing. By way of introduction and procedural background, the Appeals Chamber notes that pursuant to Article 15 of the statute, the prosecutor may initiate an investigation proprio motu without having received a referral from a state party to the Rome Statute or the Security Council of the United Nations. However, in such a case, the investigation must be authorized by a pretrial chamber before the prosecutor can proceed. On 20th November 2017, the prosecutor filed a request for authorization of an investigation into crimes allegedly committed in the Islamic Republic of Afghanistan and after Afghanistan since 1st of May 2003, as well as related crimes allegedly committed in other state parties since 1st July 2002. The request involved crimes allegedly committed by, firstly, the Taliban and affiliated groups of crimes against humanity and war crimes, the Afghan National Security Forces for war crimes, and the Armed Forces of the United States of America and its Central Intelligence Agency, the CIA, for war crimes. On 12 April 2019, the pretrial chamber 2 rejected the prosecutor's request and decided not to authorize an investigation into the situation in Afghanistan on the basis that an investigation would not serve the interests of justice. The pretrial chamber concluded that, I quote, notwithstanding the fact that all the relevant requirements are met as regard both jurisdiction and admissibility, an investigation into the situation in Afghanistan would not serve the interests of justice, end quote. On appeal, the prosecutor raises 2 grounds, namely that the pretrial chamber erred in law in seeking to make a positive determination that the initiation of an investigation into the situation in Afghanistan was in the interest of justice. This is the first ground of appeal, and further, or alternatively, that the pretrial chamber abused its discretion in assessing the interests of justice. It is the second ground of appeal. The appeals chamber, in addition to reviewing all the written submissions from the prosecutor, victims, and other participants, held a hearing for 3 days to hear oral arguments. During the hearing, the appeals chamber issued an oral decision by which it dismissed Judge Ibanez Carranza dissenting the appeals brought by the legal representatives of victims for lack of standing. The legal representatives were nevertheless permitted to make observations at the hearing as participants. The full reasons for the appeals chamber decision was filed separately yesterday, and Judge Ibanez Carranza further reasoning of her dissent will be filed later today. Turning to the merits of the appeal, the appeals chamber recalls that under the first ground of appeal, the prosecutor argues that the pretrial chamber erred in law when it decided to determine, pursuant to Article 15, paragraph 4, and Article 53, paragraph 1c, whether the initiation of an investigation would serve the interests of justice, taking into consideration the gravity of the alleged conduct, the potential victims' interests, and the likelihood that investigation would be feasible and meaningful under the relevant circumstances. The prosecutor argues that in the absence of any cause to doubt, the prosecutor's determination that there were no substantial reason to believe that investigation would not be in the interest of justice, she submits that the pretrial chamber should have agreed with her assessment under Article 53, paragraph 1c of the statute, and authorized the investigation. The appeals chamber notes that the prosecutor arguments under her first ground of appeal are predicated on the assumption that a pretrial chamber decision pursuant to Article 15, paragraph 4 of the statute should take into account the interest of justice factor of Article 53, paragraph 1c of the statute, but that the manner in which the pretrial chamber considered this factor in the present case was wrong. In contrast, the victims and certain amici curiae argue that the pretrial chamber should not have addressed the interests of justice at all. Therefore, the third issue for the appeals chamber to determine is whether the interest of justice factor under Article 53, paragraph 1c of the statute should be assessed in determining whether there is a reasonable basis to proceed with an investigation under Article 15, paragraph 4 of the statute. The appeals chambers notes that in the 5 decisions that pretrial chambers have issued to date authorizing investigations under Article 15, paragraph 4 of the statute, they have considered all the factors set out in Article 53, paragraph 1 of the statute, including, to a certain extent, the prosecutor's interest of justice assessment under Article 53, paragraph 1c of the statute. In the case at hand, and in similar vein, the pretrial chamber found that I quote, must consider on the exclusive basis of the information made available by the prosecutor whether the requirements set out in Article 53, paragraph 1a2c are met, end quote. For reasons more fully addressed in the written judgment, the appeals chamber finds that the pretrial chamber erred in its interpretation of Article 15, paragraph 4 of the statute when it found itself bound to assess the factors under Article 53, paragraph 1 of the statute. The starting point for the appeals chamber's analysis is a consideration on the function of Article 15 and 53 of the statute and the relationship between these provisions. During the drafting of the Rome Statute, these provisions were the subject of lengthy debate, and the final text reflects a delicate balance regarding the prosecutor's discretionary power to initiate investigations and the extent to which judicial review of these powers would be permitted. At the outset, the appeals chamber notes that Article 13 of the statute prescribes 3 circumstances in which the court may exercise its jurisdiction with respect to Article 5, crime. In the case of the State or Security Council referral of a situation to the court, Article 53, paragraph 1 of the statute places in principle an obligation to the prosecutor to open an investigation by providing that the prosecutor shall initiate investigation unless he or she determines that there is no reasonable basis to proceed. Article 53, paragraph 1 of the statute thus reflects an expectation that the prosecutor will proceed to investigate referred situation while allowing the prosecutor not to proceed in the limited circumstances set out in Article 53, paragraph 1a to c of the statute. A decision not to initiate an investigation under Article 53, paragraph 1 of the statute is subject to judicial control pursuant to Article 53, paragraph 3 of the statute. In contrast, Article 15 of the statute set out the procedure for the triggering of an investigation by the prosecutor proprio motu, that is, on her own motion when a situation has not been referred to her. Article 15 recognizes the discretionary nature of this power, providing in this context that it is for the prosecutor to determine whether there is a reasonable basis to initiate investigation proprio motu. If the prosecutor concludes that there is no reasonable basis to proceed, Article 15, paragraph 6 of the statute requires her to inform those who provided the information of her conclusion. The legal framework does not, however, foresee the judicial review of the prosecutor's conclusion. In the view of the Appeals Chamber, this is consistent with the discretionary nature of the power accorded to the prosecutor under Article 15 of the statute. Indeed, it would be contrary to the very concept to suggest that a duty to investigate could be imposed by the pretrial chamber in the absence of the request for authorization of an investigation by the prosecutor. Therefore, under the procedure set out in Article 15 of the statute, the pretrial chamber has a role in respect of the prosecutor's exercise of discretionary power only if she determines that there is a basis to initiate investigation proprio motu. The Appeals Chamber considers that the content and placement of Article 15 and 53, paragraph 1 of the statute make it clear that these are separate provisions addressing the initiation of investigation by the prosecutor in two distinct contexts. Article 15 of the statutes governs the initiation of a proprio motu investigation, while Article 53, paragraph 1 concerns situations which are referred to the prosecutor by the state party or the Security Council. For the purposes of authorizing a proprio motu investigation, the Appeals Chamber notes that Article 15, paragraph 4 of the statute requires a pretrial chamber at this early stage of the proceeding to only consider whether there is a reasonable factual basis to proceed with investigation in the sense of whether crimes have been committed and whether a potential case or cases arising from such investigation appear to fall within the court's jurisdiction. In this regard, the Appeals Chamber finds that Rule 48 of the rules requires the prosecutor to consider all the factors under Article 53, paragraph 1 of the statute, including the interests of justice. At the same time, there is no equivalent rule that would import this consideration for the purposes of the pretrial chamber's determination under Article 15, paragraph 4 of the statute. The interest of justice factor set out in Article 53, paragraph 1c of the statute, while part of the prosecutor's consideration under Article 15.3 of the statute, is not part of the pretrial chamber's decision under Article 15, paragraph 4 of the statute. Instead, the pretrial chamber is required to reach its own determination under Article 15, paragraph 4 of the statute as to whether there is a reasonable basis to proceed with the investigation. It is not called to review the prosecutor's analysis of the factors under Article 53, paragraph 1a to c of the statute. Accordingly, the Appeals Chamber finds that the pretrial chamber erred in deciding that an investigation into the situation of Afghanistan in the state would not serve in the interest of justice. It finds that the pretrial chamber's decision under Article 15, paragraph 4 of the statute should have addressed only whether there is a reasonable factual basis for the prosecutor to proceed with the investigation in the sense of whether crimes have been committed and whether the potential case or cases arising from such investigation would appear to fall within the court's jurisdiction. Turning to the prosecutor's second ground of appeal, the prosecutor argues that when determining that investigation to the situation in Afghanistan was not in the interest of justice, the pretrial chamber abused in discretion by failing to seek additional information from the prosecutor, misapprehending the factors it took into account for its decision, taking into account factors it should not have taken into account, and failing to take sufficient account of other relevant factors. Having determined, in relation to the prosecutor's first ground of appeal, that the pre-trial chamber erred in considering the interests of justice when deciding the prosecutor request for authorization of investigation, the appeals chamber sees no need to address the prosecutor's second ground of appeal. However, the interpretation given to the term interest of justice, as it appears in Article 53 1c of the statute by the pre-trial chamber, has been the subject of extensive submissions before the appeals chamber and has provoked much commentary from the academic community and civil society. The concept of the interest of justice is of significance under the statute, particularly for the prosecutor, who remains obliged to consider it in her assessment under Article 15, paragraph 3 and 53, paragraph 1 of the statute. For this reason, the appeals chamber is of the view that it is appropriate to provide some observations on the pre-trial chamber's approach to this concept. First, the appeals chamber underlines that Article 53, paragraph 1 of the statute is formulated in the negative. The prosecutor must consider whether there are reasons to believe that investigation would not serve the interests of justice, and need not affirmatively determine that investigation would be interested in justice, as suggested by the pre-trial chamber. Second, the appeals chamber notes that the pre-trial chamber's reasoning in support of its conclusion regarding the interests of justice were cursory, speculative, and did not refer to information capable in supporting it. Third, there is no indication that the pre-trial chamber considered the gravity of the crimes and the interests of victims as articulated by the victims themselves in conducting this assessment. In these circumstances, the appeals chamber is of the view that the pre-trial chamber did not properly assess the interests of justice. Having found that the pre-trial chamber erred by considering the interests of justice, which was the basis for its decision not to authorize an investigation, the appeals chamber finds that this error materially affected the pre-trial chamber's decision. Rule 158, paragraph 1 of the rules directs the appeals chamber to either confirm, reverse, or amend the decision appealed under Article 82, paragraph 1d of the statute. In considering whether the appeals chamber should reverse the appeals decision and remand the matter to the pre-trial chamber, the appeals chamber notes that in the appealed decision, the pre-trial chamber found that there is a reasonable basis to believe that the incidents underlying the request occurred. Elsewhere, the pre-trial chamber found that all the relevant requirements are met as regards jurisdiction. Thus, based on the prosecutor's request, the pre-trial chamber entered all the requisite findings under Article 15, paragraph 4 of the statute. That there is a reasonable factual basis to proceed with an investigation in the sense of whether crimes have been committed and that potential case or cases arising from such investigation appear to fall within the court's jurisdiction. These aspects of the pre-trial chamber's decision have not been appealed. Given these findings, if the matter were remanded to the pre-trial chamber, it would have no other recourse but to authorize the investigation. In these circumstances, and in the interest of judicial economy, the appeals chamber considers appropriate to amend the appeal decision and authorize the investigation based on the aforementioned findings of the pretrial chamber. The Appeals Chamber notes that in declining to authorize the investigation, the pretrial chamber made statements relating to the scope of any potential investigation, which in the view of the Appeals Chamber are based on legal error and incorrect understanding of its role under Article 15, paragraph 4 of the statute. These concerns the following issues. First, whether the authorization is limited to the incidents mentioned in the request and those closely linked thereto, and whether certain acts committed outside Afghanistan would amount to war crimes if the victims of these acts were captured outside Afghanistan. The Appeals Chamber will address these issues in turn. In relation to the first issue, the Appeals Chamber notes that in support of her request for authorization of investigation into the situation in Afghanistan, the prosecutor presented information relating to numerous incidents which, in her view, established a reasonable basis that crime under the jurisdiction of the court have been committed. The prosecutor clarified, however, that she did not seek authorization to investigate only in respect of these alleged crimes, but that she should be able to conduct investigation into any other alleged crimes that fall within the scope of the authorized situation. The pretrial chamber, in contrast, underlines that if it were to authorize investigation, the prosecutor could only investigate incidents mentioned in the request and authorized by the chamber, as well as those comprised within the authorization's geographical, temporal, and contextual scope or closely linked to it. For reasons more fully elaborated upon in the factual judgments, the Appeals Chamber considers that restricting the authorized investigation to the factual information obtained during the preliminary examination would erroneously inhibit the prosecutors through seeking function. Such restriction is also necessary to fulfill the purpose of Article 15, paragraph 4 of the statute in ensuring that the prosecutor does not embark on a frivolous and or politically motivated investigation, and that she remains restricted in her investigation to the contours of the situation authorized by the pretrial chamber. Therefore, the Appeals Chamber considers that authorization of investigation should not be restricted to the incidents specifically mentioned in the prosecutor's request and incidents that are closely linked to those incidents in the manner described by the pretrial chamber. In relation to the Afghanistan situation, the Appeals Chamber notes that the prosecutor presented information regarding to the alleged large-scale commission of multiple crimes against humanity and war crimes by various armed groups and actors involved in the conflict, which began prior to the entry into the force of the Rome Statutes on 17 July 2002 and continues to the present day. This information was accepted by the pretrial chamber as providing a reasonable basis to believe that the alleged events occurred and that they may constitute crimes within the jurisdiction of the court. Given the scope of the information presented by the prosecutor and accepted by the pretrial chamber, the Appeals Chamber considers that the requirements of Article 15, paragraph 4 of the statute would be met by granting the authorization the term requested by the prosecutor, which sufficiently defines the parameters of the situation. In relation to the second issue, namely whether certain acts committed outside Afghanistan would amount to war crimes if the victims of these acts were captured outside Afghanistan. The Appeals Chamber notes that in the prosecutor request, she provided information relating to alleged war crimes amounting to serious violations of Article 3 common to the four Geneva Conventions, common Article 3, of torture and cruel treatment, outrages upon personal dignity, and rape and other forms of sexual violence committed as part of a policy by members of the CIA in a number of detention facilities in Afghanistan, as well as in detention facilities located on the territory of other state parties. For the purpose of the request, the prosecutor referred only to crimes allegedly committed by the CIA on the territory of state parties against individuals that she considered to have a nexus to the armed conflict in Afghanistan. The Appeals Chamber notes that the nexus requirement for war crimes is recognized in the elements of crimes. It has been observed that the function of the nexus requirement is to differentiate war crimes, for example, the killing or rape of a prisoner of war, from ordinary or common crimes under domestic law, such as the common crime of murder and rape. In the appealed decision, the pretrial chamber found that the alleged incidents which the prosecutor attributed to the CIA fell outside of the court's jurisdiction, since these are said to have occurred against persons captured elsewhere than Afghanistan. The pretrial chamber considers that the acts in question lack the nexus with an internal armed conflict required to trigger the application of international humanitarian law. The pretrial chamber supported its view by the reference to the chapeau of Common Article 3, stating that, I quote, both the wording and the spirit of Common Article 3 to the Geneva Conventions are univocal, and in confirming its territorial scope within the borders of the state where the hostilities are actually occurred. End quote. While it is true that chapeau of Common Article 3 refers to an armed conflict not of an international character occurring in the territory of one of the high contracting parties, this phrase does not have the function ascribed to it by the pretrial chamber, namely to limit the applicability of the provision of the state to the state on the territory of which the armed conflict occurs. Relating to the view of the Appeals Chamber, it simply describes the circumstances under which Common Article 3 applies, namely there must be an armed conflict not of international character in one of the state parties to the Geneva Convention. This view finds support in the position of the International Committee of the Red Cross, which suggests that this phrase does not have the effect of restricting the application of Common Article 3 to the territory of the state in which the armed conflict occurs, but rather was aimed to ensuring that the provision would bind only those states that had ratified the Geneva Convention. The ICRC indicated that the phrase has lost its importance in practice, as any armed conflict not of an international character cannot but take place on the territory of one of the parties to the convention, given the universal ratification of the Geneva Conventions. Indeed, all states relevant to the allegation in question, Afghanistan, Poland, Romania and Lithuania, as well as the United States, are parties to the four Geneva Conventions. The remaining text of Common Article 3 also does not expressly limit the applicability of Common Article 3 to the territory of the state where the conflict occurs. To the contrary, the minimum provisions set out in subparagraph 1 stipulate that those falling under its protection, and I quote, shall in all circumstances be treated humanly, and that the certain acts against these persons shall remain prohibited at any time and in any place whatsoever. End quote. Therefore, contrary to the pre-trial chamber's finding, the text of Common Article 3 read in its totality does not suggest that the requisite nexus with the armed conflict in Afghanistan cannot exist if the criminal conduct occurred outside Afghanistan and the victims was not captured in Afghanistan. Importantly, such a conclusion would also be contrary to the purpose of Common Article 3, which is to provide minimum guarantees in relation to armed conflicts. In sum, the Appeals Chamber considers that the pre-trial chamber's finding regarding the nexus requirement was incorrect. There is no reason to limit the prosecutor's investigation in the manner envisaged by the pre-trial chamber. This is not to say that the Appeals Chamber has determined that any or all of the incidents listed Annex 2C to the prosecutor's request would necessarily have the requisite nexus to qualify as war crimes. When the relevant circumstances have been established in the course of investigation into the situation as whole, the prosecutor will be in a position to evaluate the applicable law, the significance of the fact that capture is alleged to have taken place outside Afghanistan, and whether one or more individual cases fall within the court's jurisdiction. In conclusion, the Appeals Chamber considers it appropriate to amend the appeal decision to the effect that the prosecutor is authorized to commence investigation in relation to alleged crimes committed on the territory of Afghanistan in the period since 1st May 2003, as well as other alleged crimes that have a nexus to the armed conflict in Afghanistan and are sufficiently linked to the situation and were committed on the territory of other state parties in the period since 1st July 2002. Judge Ibanez Carranza appends a separate opinion to this judgment which reflects her reasoning on the interpretation of Article 15 and its relationship with Article 53, paragraph 1c of the statute. This concludes my summary of the judgment. I wish to thank the legal team of the Appeals Chamber, the interpreters, court reporters, other registry staff, and parties and participants. I now declare this session closed.
All rise. We will obey.